A mother wants to move to Europe with her child. The father, still in South Africa, says no. A court must decide, not just where the child lives, but how they grow up, who they love, who they lose. Now, imagine that court has no roadmap, no specialist judge, no clear standard. That's where we are in South Africa in 2025. But by 2030, we could change everything. I'm Simon Dippenaar, a family lawyer in Cape Town. Today, I want to offer a vision, how South Africa can reform its cross-border custody system, not someday, but by 2030. Because every year, more children straddle two homes, two passports, and sometimes two court systems. Our laws are compassionate, but our procedures are outdated. And the families caught in the middle, they suffer. It's time to modernize, with judicial precision, international insight, and unwavering focus on the child. Part 1. What's broken? Let's start with what's not working. In South Africa, if one parent wants to relocate with a child, there's no clear legal test. Each judge decides based on the best interest of the child, but without guidelines. That means outcomes vary wildly from one courtroom to another. One parent walks away with permission, another is blocked, and both wonder if it was just luck of the draw. Enforcement is no better. A parent with a court order abroad often can't enforce it in South Africa unless they go through complex litigation to secure a mirror order. And in Hague Convention child abduction cases, where time is everything, some courts take months to deliver decisions that should take 6 weeks. In 2024, the SCA had to warn judges, don't let abductors benefit from delay. But the problem isn't bad faith, it's structural weakness. No specialization, no fast-track rules, no harmonized approach. Part 2, what the world is doing. Other countries have solved this. In the European Union, under Brussels II, a custody order from one country is enforceable in another. Fast, no red tape. If a child is abducted and a court wrongfully refuses to return them, the home country can issue a trumping return order, and it must be obeyed. In Australia, they've joined multiple Hague Conventions. They routinely enforce foreign custody orders, and their family law courts specialize in cross-border cases. In the Netherlands, all Hague cases go to one court, the District Court of The Hague. That means judges know the treaty inside and out. Cases are heard fast, consistently. They even offer mediation right after the Hague application is filed, sometimes resolving the matter before it ever reaches court. These are not distant dreams. They're models, and they work. Part 3, best practices we can adopt. So what can South Africa learn? First, specialization. Create a bench of judges trained in cross-border custody, Hague law, and foreign order enforcement. Whether we call it a specialist division or simply designate high court judges, experience breeds consistency. Second, speed. Hague cases must move. The 6-week rule isn't a guideline, it's a safeguard for children. Our courts need case management tools to keep these matters on track. Third, mirror orders. If a South African parent gets custody abroad, our courts should be able to register that order quickly, and vice versa. Mirror clauses in relocation judgments can also require the moving parent to obtain a foreign order that replicates South Africa's terms. Fourth, undertakings. Want to return a child safely? Make sure housing, schooling, and non-prosecution are guaranteed in writing. This is standard in the UK and Dutch courts, and it works. Fifth, mediation and parenting plans. Before any court hears a relocation or access case, let parents try to work out a cross-border parenting plan. Sometimes all it takes is structure, travel schedules, school holidays, WhatsApp calls. Structured rights are better than theoretical ones. Part 4, the roadmap to 2030. Now let's look forward. Here's what South Africa could achieve with will and vision by 2030. Pass relocation guidelines. Amend the Children's Act with a list of clear factors for judges to weigh, like what's proposed in the SALRC relocation bill. Join the 1996 Hague Convention. This lets South Africa recognize and enforce foreign custody and guardianship orders more easily. Formalize mirror orders. Allow parties to register foreign judgments in South Africa without relitigating, and make this reciprocal abroad. Strengthen the central authority. Resource the Family Advocate's Office to guide Hague applications, appear in court and coordinate with foreign officials. Train specialist judges. Set up a bench or panel within each high court who know this field well. Streamline appeals. Stop appeals from delaying enforcement. Create special fast-track rules for return orders. Embrace mediation early. Introduce pre-litigation parenting plan protocols for cross-border disputes. Listen to children. Give mature minors a structured way to express their views safely and age-appropriately. Track performance. Publish annual reports on return times, compliance, and judicial efficiency. These steps are not radical. They're overdue. By 2030, every child in a cross-border custody dispute should have access to a trained judge, a clear procedure, a quick decision, and enforceable rights. Parents shouldn't fear months of litigation or being stranded in a foreign country or losing their child because the court moved too slowly. Cross-border justice is no longer a fringe issue. It's a 21st century necessity. And South Africa has the capacity, the talent, and the legal foundation to lead. All we need is to start. I'm Simon Dippenaar. Let's make this vision real for our children and for the families across borders who deserve certainty, dignity, and peace.